and thank you for joining us. My name is Katie Perez, and I'm a Senior Associate here at Scott Legal PC. Today, we are going to spend some time talking about the Extraordinary Ability Visa and the green cards, but just a few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E-2 visa and has been on several different visas, including an F-1, a T-N, a B, and an H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E-2, E-1, T-N, family immigration, national interest waivers, EB-5s, extraordinary ability visas, and more. We will continue this webinar series doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and will be available on YouTube. We will also send a link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout this presentation, please put them in the chat box and we will address them at the end of the presentation. So today I will be presenting the first half of the webinar. As I mentioned, my name is Katie Perez and I'm a Senior Associate here at Scott Legal. And my background does include 10 years of experience at USCIS, where I did work on the Extraordinary Ability Visas. We're also joined by Kelly Weiner. Kelly is our partner here at Scott Legal and has extensive experience processing the EB-2 National Interest Waivers, EB-1s, O-1s, and green card matters. Okay, so we will get started. Okay, so what are the extraordinary ability visa categories? The first ones we have here listed are the O-1A and the O-1B, which are both temporary non-immigrant visas. With these visas, you will have the ability to work here in the U.S., but you intend to come here temporarily to fulfill that work. In contrast, the green card option would be for someone who intends to come here permanently. So again, we have the O-1A. The temporary non-immigrant visa. This is for individuals with extraordinary ability in the sciences, education, business, or athletics. It has a very high standard in which you must be one of a small percentage who's risen to the very top of your field in your profession. We also have the O-1B. This is a temporary non-immigrant visa for people with extraordinary ability in the arts. O-1Bs are treated a little bit differently than the O-1A, and the standard is slightly lower. The person must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O-1B visa, there is also kind of a subcategory. This is for people who have extraordinary ability in the motion picture and television industry. The standard for the motion picture and television industry is a little bit higher. You must show that you have a record of extraordinary achievement in the motion picture and television industry, such that you have a very high level of accomplishment, evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, and leading in the field. So within this category, it'd be like in relation to your peers in the industry. Okay, so we'll talk a little bit more about the requirements for the green card category. So first we have here the EB-1A. This is very similar to the requirements of the O-1A and the O-1B, what those look like, but there's not the separate category for the arts. So this category is for those with the extraordinary ability in the sciences, arts, education, business, or athletics, and it's all under one umbrella of the EB-1A. So the individuals must be one of a small percentage who's risen to the very top of their field of endeavor, and you have sustained this international acclaim, and your achievements have been recognized in your field of expertise. So importantly, with this category, you must be coming to the U.S. to continue to work in your area of extraordinary ability. If someone's had a very prominent career and they just want to retire, then that's not really going to work for the EB-1A. The government will want to see a statement of proposed intent of what you plan to do here in the U.S., and it does need to be related to your area of extraordinary ability. We also have the EB-2, the National Interest Waiver green card. This one's not always lumped in directly with the extraordinary ability visas, but it is a good option for someone. Um, Maybe they were on an O-1B and they don't quite meet the EB-1A standard yet, but still have a very impressive background and are working on an endeavor in the U.S. that has substantial merit and national importance. So you may be eligible for the employment-based second preference if you are a member of the professions holding an advanced degree or its equivalent, if you have a bachelor's degree and 5 years of progressive work experience, or you are a person with exceptional ability. These are the threshold requirements. So if you are claiming exceptional ability, you would need to explain how your area of exceptional ability relates to your proposed endeavor, and the term endeavor is more specific than just a general occupation. So you would need to offer details not only as to what maybe the occupation normally involves, but also what work you that you propose to undertake, specifically within the occupation. So, for example, if your occupation is engineer, then you would want to provide an explanation of your proposed endeavor, and it should be very specific, like the specific projects, the goals that you will work on as the engineer. So you'll also need to provide a detailed description explaining your proposed endeavor and then provide the supporting documents to establish that this endeavor is of national importance and has a substantial merit. You will also need to show that you as the individual are well positioned within the field to advance this particular endeavor. So there needs to be kind of a nexus between everything, your expertise, your experience, and what you plan on working on. So then based on that, you would argue that it's beneficial to the U.S. to waive the normal labor certification process that requires the U.S. employer and a labor market test. So you wouldn't have to go through that process because what you're working on is so important and so beneficial to have you in here in the U.S. that they would waive it. So another important thing about the EB-1A and the EB-2 National Interest Waiver is that you can self-petition. There's a little bit more flexibility in some ways with these two petitions versus the O-1A and the O-1B. With the O-1A and the O-1B, you would need to have um, an employer petition or an agent operating for a foreign employer versus just doing it yourself. Okay, so we'll talk a little bit more detail about the specific O-1A requirements and what you would need to demonstrate. So for the O-1A, you can show that you have a major internationally recognized award like a Nobel Peace Prize or a Pulitzer, or more commonly, people are going to qualify based on showing that they meet at least 3 out of the following criteria. 3 is the minimum, but you would want to have more if possible. So first we have is the receipt of nationally or internationally recognized prizes or awards. So you would want to consider, is the award national, the whole nation, is it international, more than one country? A prize is something offered or striven for, like in a competition or contest. An award is something that is conferred or bestowed upon you, usually based on your merit. Things to consider: the criteria for winning the prize, the past honorees, the number of prizes or awards given each year, and then limitations on eligible competitors. Um, you would want to think just really, how did you win this award? Were you a student when you earned it? Were you at a university? If so, this may not be as compelling for the petition. So you want to really think strategically about the evidence you provide in support of your petition. When an officer looks at it, they will look at it holistically. So if the evidence you're providing is a little bit weak, it could bring down the whole profile of your petition. So you do want to think about the evidence overall. So including an award like a student award that you won at a university may not be the strongest evidence. However, if you were at a university and you won a very prestigious award where other professionals in the field also competed with you, you may want to include this as evidence in support of your petition because it really could support that you have risen to the top of your field. Next, we have membership in associations in the field, which require outstanding achievements. So here you would want a membership that actually requires you to have some outstanding achievement in order to be invited and in order to apply to become a member of that association. So it is important to look at what are the requirements for entry. Can anybody enter, or does it require outstanding achievements? Factors that might suggest membership is not an outstanding achievement could include, is it just based on a level of your education? Is it based on a payment or a fee? Something like the Bar Association for Attorneys would not work. So anyone who's passed the bar can join by paying a fee. So it doesn't necessarily require outstanding achievements to become a lawyer. Next, we also have published materials in professional or major trade publications or major media about you or your work or something you're working on. So this should be about you, but the publication could cover a broader topic and include substantial discussion of your work and mention you in connection to your work. But the government will focus heavily on whether the article was about you. Next, we have original scientific, scholarly, or business-related contributions of major significance in the field. So an original contribution could include patents or processes. It is important for you to show how the work has already impacted the field. The potential impact is not sufficient for this criteria. So oftentimes people will commonly provide testimonials about their work, but the testimonials provide the potential impact of the work they're doing, and this would not be sufficient. It should already have had an impact on the field. And the testimonials should explain in detail how the work has been a major significance in the field. We also have authorship of scholarly articles in professional journals or major media in the field. So this can include publications in professionally relevant journals or published conference presentations at nationally or internationally recognized conferences. This criteria often applies to those who are involved in academics, but it could apply to other fields as well. Next, we have a high salary or other remuneration for services as evidenced by contracts or other reliable evidence. So here again, you are going to look at what is your area of expertise, where are you working, what is your occupation, and where will you be working. So are you earning a salary in relation to others in your field? You can show this by comparing your salary to labor statistics. That's often what people do. But make sure you're comparing the apples to apples. If you're giving an hourly wage, you would also want to provide the reviewing officer with an hourly wage to compare it to. Okay, participation on a panel or individually as a judge of the work of others. You must show that you've participated as a judge of the work of others in your same or allied field. An example of this would include or could include reviewing abstracts or journal papers submitted to scholarly conferences or just serving as a peer reviewer of the scholarly publications. So you would want to document that you did do this peer review work. A lot of times this could be like an email or a request from the journal asking you to review the paper, and then it would be accompanied by evidence that you actually completed the review. We also have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would want to explain your role in detail with the organization. So explain how it was critical or essential. You might want to explain how you contributed in some way of significant importance to this organization. Essential would be really like, was your role integral to the entity? Did you have a leadership role in the organization? This would often qualify as essential or critical. You do also have to show, again, that the organization is distinguished. So if you're a CEO of a very small company that nobody's ever heard of, you could likely show that, you did serve in this critical or essential role. But if the company is not well known, it's not distinguished, you wouldn't be able to satisfy this criteria. So conversely, if you worked at a company like Apple, it is very well known and distinguished company. But if you're working in say, for example, a factory just boxing up the phones, then you may not have this critical or essential role. So it is very important to detail to the reviewing officer, your role, what did you do, and maybe provide a comparison of your role in comparison to others within the whole organization. Okay, next we'll discuss a little bit the O-1B requirements. So again, this category is for those in the arts and those in the motion picture television industry. The O-1B has a similar structure to the O-1A. in the sense that you will qualify by either one significant national or international award, like a Grammy or an Oscar, or most people would satisfy or be eligible for the visa based on satisfying 3 out of the following 6 criteria. So first is having been and will perform as a lead or starring participant in a production or event with a distinguished reputation. Evidence may demonstrate a lead role by establishing that the person has a principal role in the event or production. A starring role means a position of great prominence relative to others in the event or production. Generally, the difficulty with this criterion is showing the future element. So there is having been a starring performer and then also in the future. So it can be hard to show this future production will have this distinguished reputation in some cases because you may not have these critical reviews or advertisements yet. Next, we have critical reviews or other published material in professional or major media by or about the beneficiary. So here the difficulty can come with showing, the media is major. The government doesn't hold much weight to articles you can self-publish or that are not vetted versus an article maybe in the New York Times, something like that. So you must provide evidence that demonstrates you are recognized for achievements nationally or internationally. We also have the evidence that you have performed as a lead or will perform as a lead or starring or critical role for an organization or establishment with a distinguished reputation. So this element or this criterion is very important. It's important to remember that the role needs to be critical to the organization, not just an event or production. So there are 2 separate criteria for this visa category, and a lot of times people conflate these 2 things. You could make an argument that you might have been a starring movie star in a movie, and then because you're such a big movie star, really you did have a critical role for the organization. But it is best not to conflate them and keep them separate, but really give a very detailed description on if you're doing the first one, a role in an event or production, and then this third one, your role within the organization overall. So you might want to provide a comparison of your position within this organization, explain in detail how it was critical. Again, you would also have to show that the organization has a distinguished reputation. Let's see. Okay, so you also could show that you have a record of major commercial or critically acclaimed successes in performing arts, as shown by the box office receipts or record, cassette, compact disc, or video sales. As you can notice that this criterion does have a lot of outdated information or requirements, such as the cassette sales. People don't do that anymore. So you may have to be more creative if you're trying to satisfy this element. So for example, you may not have cassette sales, but maybe you do have a YouTube channel and you are very successful on this YouTube channel. You generate a lot of income, a lot of commercial success. So if you are demonstrating critically acclaimed successes, the evidence should demonstrate that you have received this public-facing praise or positive reviews in your field. So we also have evidence of recognition for achievements or from organizations, government agencies, or other recognized experts in the field. Many times for this one, you would just submit a testimonial from someone who's recognized in the field. The testimonial really needs to detail what are your achievements. So if you speak to someone's work ethic and that they have a lot of potential in the field, it wouldn't be sufficient. It would really be important to focus on the achievements. The government will really focus on, does this person have an achievement? Next one is evidence of having commanded a high salary or other significantly high remuneration for services in relation to others. So again, you can satisfy this by providing the labor statistics to provide this comparison. And again, you just want to compare apples to apples. So if you're giving this hourly wage, you would also want to give the government an hourly wage to compare it to. So lastly, within this category, there is also something called comparable evidence. So that is to say, if you're applying for the O&B in a very kind of niche field, and you feel the above criteria don't apply to you, you would need to explain to the government why they don't apply, and then you'd also need to provide evidence that is comparable. This one is kind of a big hurdle to meet, but it is something you could consider. As an previous adjudicator, I had never seen anyone satisfy this by providing the other comparable evidence. So it is more rare. Something else to consider with the comparable evidence, it's not available for those in the motion picture and television industry. Okay. So just quickly, we'll go over the differences between the O&A and the O&B. Again, the O&A is for those within the sciences, education, business, or athletics. The O&B is for those in the arts and the motion picture and television industry. The standard for the O1A is one of the small percentage who's risen to the very top of their field of endeavor. The arts, you have a high level of achievement as evidenced by a degree of skill and recognition substantially um, above that ordinarily encountered. And then for the motion picture and television industry, you would want to show that you have a level of acclaim substantially above that of others in the field, so your peers. The O1A and the O1B can both be issued for 3 years. You can receive an extension. The extension would depend on your work. So if you're just trying to continue the same work and maybe your job has extended, you could receive an extension from the government for a year. If you do have new employment, so you would, for example, you have a new employer, a whole new contract, you can receive 3 years again. If you have family as an O1A or an O1B and you want to bring them along, you can bring them with you so your family can travel. It would be important to note that if you have a spouse, though, they wouldn't be able to work as a dependent. They would have to find a different visa category that they would fit into to be eligible to work. So again, for the dependents, this could include your spouse and children under 21 years of age. The children can attend school if that is needed. Okay, let's see. Oh, and one other thing, if I wanted to mention about the O&Bs, if you are um, if you are in a category that could maybe be an O&A or an O&B, you may want to consider filing as an O&B just because the standard is a little bit lower. Okay. So now we will discuss just a little bit about the EB-1A requirements. The EB-1A requirements are very similar to the O&A and the O&B. Some of the language differs a little bit, but it is very similar because it incorporates the arts, sciences, education, business, and athletics all together under that one umbrella. The structure for qualifying for the EB-1A is also very similar to the O1A and the O1B, where you can qualify with a major award. However, most people will qualify based on showing that they meet at least 3 out of the following 10 criteria listed in the regulations. So these criteria are some are the same, but a lot of them are very similar to what we described in the previous slides as well. Again, we'll just discuss them quickly because they are so similar. The first one, though, is evidence of receipt or less nationally or internationally recognized prizes or awards for excellence. Evidence of your membership in associations in the field which demand outstanding achievements for the members. Evidence of published materials about you in professional or major trade publications or other major media. Evidence that you have been asked to judge the work of others, either individually or on a panel. Evidence of your original scholarly, artistic, athletic, or business-related contributions that are a major significance in the field. Evidence of your authorship of scholarly articles in professional or major trade publications or other major media. Evidence that your work has been displayed at artistic exhibitions or showcases, and evidence that you have performed as a leading or critical role with a distinguished organization, evidence that you've commanded this high salary or significantly high remuneration, and evidence of your commercial success in the performing arts. So now we will switch over to our partner, Kelly, who will continue with the EB-1A requirements. So here we go.
Thank you, Katie. So the requirements, are very similar, as Katie noted, to the O-1A. And the structure of qualifying is very similar, where you show that you meet at least three, but usually you want to show as many as possible of the criteria. And the analysis is kind of two steps, although we will talk about something, a major change that's happened recently, although it's not kind of a, national change yet. So the way that they will adjudicate them at this point is based on something called the Kazarian analysis, and this is where first they're going to examine: did you show that you meet at least three out of the 10 criteria? Do we have documentation, for at least three? Um, However, then the second step of the analysis is them looking at the quality of the evidence in totality to determine, the final merits determination of, do you, reach this very small percentage of people who've risen to the very top of their field. And so sometimes that means what can happen is they can say, well, you've provided evidence for at least three of the criteria. However, we feel based on our final merits determination that you're not someone who qualifies for the EB-1A. And there's been a lot of over the years pushback against this analysis because there is this kind of subjective element to it. And that's sometimes led to kind of different types of adjudications. And so as listed here on January 28th, 2026, there was a federal district court in Nebraska that ruled that the adoption of the Kazarian two-step test was unlawful. And it reversed a denial that was, made on the basis of a final merits determination. So this decision is not binding across the country. That means that, it's not something that has kind of changed the entire standard. However, this is persuasive authority for other courts, and we are hopeful or hoping that there could be some policy changes as a result of this in how EB-1As are adjudicated. But for a very long time, and for the majority, of EB-1As, they're still being adjudicated under this Kazarian analysis. All right, let's talk a little bit about the National Interest Waiver. And this one is not always lumped in with the extraordinary ability visa categories, but it is an important one, and it is often a good option for people with who may be eligible for the EB-1A in the future, but perhaps are not yet, or maybe are working in areas of substantial merit and national importance to the United States. So the National Interest Waiver is a green card category under the EB-2, and the EB-2 has a threshold requirement of either an advanced degree, which is a U.S. master's degree or higher, or its equivalent, which would be a U.S. bachelor's plus 5 years of post-baccalaureate progressive work experience in that particular profession. If you do not meet the EB-2 threshold standard based on education, you can also meet it based on showing exceptional ability. So this is a lower standard than extraordinary ability, and you need to show that you meet at least three of seven criteria, which are listed here. Things like an academic record showing your degree, letters documenting 10 years of full-time experience, a license to practice in your profession, evidence you've commanded a high salary, membership in professional associations. So even though some of the criteria are similar to kind of the extraordinary ability standards, it's an exceptional ability standard. And these again are just threshold requirements. So if you have this, it doesn't mean you qualify for the EB-2 or you qualify for the National Interest Waiver. It means that you meet this initial step. So for the EB-2, you would look first, do you meet this initial step? And if so, then you can proceed to see whether or not the National Interest Waiver, whether you would qualify based on the additional requirements that are in place for that. And we can go to the next slide. All right. So for the national interest waiver, you're essentially saying under the EB-2, most of the time, there's a process for company sponsorship where a U.S. employer is going to sponsor the employee and conduct a labor market test and see if there's any willing, qualified, and available U.S. workers for the job. For the national interest waiver, the applicant is saying, please waive that normal company sponsorship labor market test requirement. That should be waived because I'm working in an area that has substantial merit and national importance to the United States. I'm well positioned to advance that endeavor, and that on balance, it would be beneficial to the United States to waive these normal requirements of a job offer and labor certification. And we'll go over each of those in a little more detail. So, to prove that your endeavor has substantial merit and national importance, sometimes people will say, "Well, I work in, energy, or I work, there's kind of very broad fields that have merit or that have national importance, and it has to be a lot more targeted than that. So, it's not just that you are, an associate at a company that is doing something of substantial merit and national importance. It has to be, a particular endeavor, and you have to show that you individually are well positioned to advance that endeavor. So your role in it needs to be very key and critical and essential. We work with a lot of entrepreneurs who do the National Interest Waiver. So often they are something about their business or what their business is doing has substantial merit and national importance. It's important to know that the endeavor has to go beyond, like if you're an entrepreneur, it has to go beyond just, I'm going to do a really great job for my clients. To show that you have that national importance, it generally means that the work that you're doing in your endeavor has to be impacting the industry, maybe changing standards, maybe you're a thought leader. So the things that you would include in this, to meet this criteria, one are kind of expert letters. So these serve two functions. One is, experts who are defining the field. Why does it have substantial merit? Why does it have national importance? The letters would also speak to you individually. So why, are you the right person to advance this endeavor? How are they aware of you? How are they aware of your work? So they serve those two functions. Government pronouncements and declarations. So things that have national importance are usually kind of, put into different kind of government materials. And this can be very persuasive to show, this is what I'm working on. It does have this national importance. It does have this substantial merit. Other data that you have, showing the importance, so these can be, kind of private industry, philanthropic, areas, state and local actors. So anything that kind of defines your endeavor, defines the field, explains why it has substantial merit, explains why it has national importance. Um, but again, needs to go beyond just my company does a really good thing and we do a really good job for our clients. Then you need to show you are well positioned to advance the endeavor. So this is where people who maybe, are not quite at the EB-1A standard, but do have a very impressive background. Sometimes the National Interest Waiver can be a good option for them. You need to show your education and experience. A track record of success is very important. You don't need to have done the exact thing you're doing now, but you do want to have some type of record of success, ideally in a peripheral or related, if not directly on point to the project that you're doing, to show that you have the ability to carry it through. Any intellectual property that you have, any advancement that you've made towards your endeavor. Sometimes we have clients, for example, who are on an E2 and build up their business over several years, and then over time it starts to kind of meet the standard to be able to show a track record of success. Um, so these are all things to consider for that second prong. And then finally, that there's a showing on balance that it's beneficial to the U.S. to waive, the normal requirements. If you're an entrepreneur, this argument can be made relatively easily in the sense that the labor certification process is generally not available to entrepreneurs. Just the way that it's set up, the owner of the company cannot themselves kind of sponsor themselves. Um, you can also argue that the work that you're doing is so key, so important that even if there's others in the United States who are doing it, it's still vastly beneficial to the US for you to be doing it as well. So these are all, important things to consider as you're making your arguments for the national interest waiver. This is a category that, was kind of broadened, when there was a change to the standard under the case matter of Danazar. However, we are in a time right now where the adjudications are getting harsher, and it is getting harder to get these cases through. All right, so expert opinion letters. These are used, in the EB-1, the O-1, the National Interest Waiver. What is included. Important to recognize that expert opinion letters are not recommendation letters. So sometimes people will kind of say, it's fine. I have lots of letters of people saying they've worked with me, they like working with me, I do a good job. That's really not what's needed, for these types of cases. Um, you want to obtain, kind of expert letters from key individuals in the industry. So that's particularly important, I think, for the national interest waiver, where often the experts are kind of defining your industry, why it has substantial merit, why it has national importance. You want to think about, we talk about kind of inner and outer circle recommenders, meaning, people who know you, who have worked with you, maybe former supervisors, colleagues, clients. And then there's outer circle, and these would be people that are prominent in your industry, but maybe know of you only through your work, but have not worked with you directly. We're not your former bosses. Um, so anybody that, can speak to your work, maybe they, became aware of you at a conference and you kept in touch professionally and they're following what you do. These types of things are very helpful. The letter writer themselves should be someone who is prominent in the industry and themselves often would qualify, for an EB-1A, O-1, or national interest waiver. You really want to make the discussion of your work, recognition, accomplishments, and achievements specific. Really talking about what it is you've accomplished, what it is that you've done. Um, giving these examples and then backing that up with objective evidence. So the most successful expert letters are going to kind of tie back into the objective evidence that you're providing. So not just that they're saying, this award that was won is like the Oscars of our industry, but that there's actual objective evidence elsewhere, of what they're saying. All right. So, kind of which category to apply for. So, first things to consider, do you want to stay in the U.S. temporarily or permanently? So, if you just want to come for a few years and work, the O-1A, the O-1B are the right path for that. That is a non-immigrant temporary visa, generally can be granted, as Katie said, for 3 years initially, and then extended in increments of 1 year or sometimes 3 years if it's a new employer or new set of projects. If you want to live and work in the US permanently, then the EB-1A and the National Interest Waiver are the good options. These are green card categories. Once you get your green card, you can, live and work in the United States full time, anywhere, and can eventually apply for US citizenship. So if you also want to consider, do you have a U.S. employer or agent? Do you want to self-petition? So the EB-1A and the National Interest Waiver allow you to explicitly self-petition. So even if you are working for a U.S. company and that work is a big part of your petition, you still can self-petition, which is often a good idea strategically because if you do change jobs or employers during the process, just easier if the petition was filed in your name, not in the employer name. Um, for the O-1A and O-1B, you will have to have a U.S. employer or a U.S. agent. That can sometimes look like the O-1A or O-1B having their own company, which maybe they have other members of the company, or maybe they own that company. But there is kind of explicit language in the regulations that explains that a U.S. company, even if owned by the O-1 employee, is considered kind of, a separate entity and can be the petitioner. So that is something to consider as well. Family consideration. So the O-1A and O-1B, your spouse and any unmarried children under 21 can come to the U.S. as O-3 dependents. They can study in the U.S., although they can't work. And then for the green card categories, your spouse and any unmarried children under 21 can apply for your green cards as your dependents. When you apply for that, if you're in the United States doing an adjustment of status, they can also apply for work and travel authorization with you. And then once approved, you would all get your green cards and again, all be able to, apply for US citizenship in the future if you chose to do that. All right, so just some considerations. Let's say you come on an O-1, or a different temporary visa and you want to move to a green card. Important to consider that just because you were approved for an O-1A or an O-1B, it does not mean you are automatically going to get the EB-1A. I think sometimes there's a misconception that being on a temporary visa for a certain number of years will automatically lead to qualifying for a green card, and that is not the case. You can be on an O-1 for many years, and still perhaps not qualify for the EB-1A. However, if let's say you got your O-1, but it was very difficult to get, maybe you got a really difficult request for evidence, you had to submit a lot of extra evidence, you can work towards, getting a stronger profile for the EB-1A. So it may be that when you're in the US on your O-1A, you're using that time to really build your profile so that you have a stronger case when you do ultimately apply for the EB-1A. You also want to consider when you're applying for a green card, how much time is left on your underlying visa. So some visas are harder to extend or subject to more scrutiny once you have filed a green card petition. The O-1 it's not a full dual intent visa. So it's not like an H-1B or an L where you can have a green card petition pending and it has kind of no impact on your ability to renew or extend the visa. With the O-1, for example, let's say you filed a green card application in the United States. At that point, you're not going to be able to, easily you can't get a new visa because you can't leave the United States without abandoning your green card application. There's also some other visa types like the TN or the F1 that have kind of very high standards for non-immigrant intent. Once you filed a green card petition for those, again, not something where you'll be able to renew or extend. You also want to consider your family. So if you do have children and you want them to join you, on your green card application, you want to make sure you're filing in enough time that the children aren't aging out. The EB-1A category is, generally current worldwide, has remained current, but EB-2, which is for the NIW, has, kind of flip-flopped. Right now it's current, but it has been backlogged for quite a long time. So something to keep in mind, just to kind of plan early, plan ahead, especially if you want to include children in your application. All right, our extraordinary ability categories available for entrepreneurs. They are, and we do a fair number of these. For the EB-1A and the National Interest Waiver, you can self-petition. So these are great options for entrepreneurs, who generally are not going to be eligible for that company sponsorship, through the perm process. When the National Interest Waiver standard was changed under matter of Danisar, there was even language in the decision that made this a much friendlier category for entrepreneurs. They specifically called out that that is who they expected, might benefit from this because of their inability to take advantage of the labor certification perm process. It's also possible to apply for an O-1A as an entrepreneur. You do have to have kind of a separate corporate entity. It's better. So you can't self-petition in the same way, just under your own name. You need to have a separate entity, and then better if you do have other co-owners with you and you're not sole owner, although that is still possible. All right. So we did get some questions. So we can kind of take a look at these, and I'll send some to Katie as our who I know has extensive experience adjudicating O-1s. So Katie, this first one, it says,
Mhm.
is IEEE senior memberships sufficient to meet an O-1A or an EB-1A?
I would have to look at that specific membership specifically, but it would just, you would want to analyze how does someone become a member? Is it based on, your level of education? Again, like can you pay to be a member? But I know with the IEEE one, that's even referenced in the USCIS policy manual, but it's actually as a fellow. So maybe that could give.
Yeah, and I think an important thing as well is that one thing on its own, right, is never
Mhm,
going to meet the full criteria. So this senior membership could be used as one element of one of the criteria, but you
mhm.
would obviously need to have significantly more evidence to qualify.
And I would say it just really depends on how you become a member, an analysis of that. So, can anyone become a member? Is it based on your education, occupation, that sort of thing? But to really look at, does it require achievements to become a member for that association?
Yeah, absolutely. So for a second question, authorship of scholarly articles, how many should have been published for the EB-1A? I would say again with this, and again, this is a common question. However,
Mhm.
really you're looking holistically at the person's entire profile. So for example, and what industry are they in? So there may be some industries where having a very high number of scholarly articles is required to show you've risen to the very top of your field. And there may be industries like when we work with entrepreneurs where maybe you have published, but not extensively, but it can still be used. So there's not any one particular number. It is something where you'd have to look holistically at the field, and kind of compare to see what is the norm in your field and have you exceeded that.
And then just really quickly for that, whenever you're considering the type of evidence and you're trying to see is like what is the number for the evidence, it is more important like the quality over the quantity. If you published you had 100 articles published about you, but those were like self-published versus maybe one article in the New York Times, which is a giant paper everybody knows about. I think as the officer, they would hold a lot more weight to the New York Times, which would just be one article versus 100 articles. So same with the scholarly articles.
Yeah, absolutely. So for high salary people from Canada, how is it compared for EB-1? Let's say you get 150,000 Canadian dollars living in Canada. How does it compare to the US? Um, so
So,
Katie, do you want to
oh,
talk about how
sure.
they
So they
handle
would
that?
Sure. The officer adjudicating should compare to your locality. So if you're in Canada, they should base it off of where you're living in Canada. So, I mean, you
Exactly.
as the beneficiary or your petitioner should provide the evidence for the officer, you know, that your salary is high in comparison to others where you live in your locality because you don't want to make the officer go figure that out.
Exactly. So the next one, Katie, for published material, does the media have to be only in the US or would somewhere in India be acceptable, for example?
Similar to like the pay, it is can be locality. So if you have, you are published in a really big paper in India, that would be amazing. You should definitely provide it. And then you'd want to give some background information on that paper. Provide to the officer the, information just on how big this paper really is. So the subscriptions and that sort of thing. How many people visit their website a month? There's that kind of thing.
Perfect. So someone's asked if we're approved with an EB-1A, I-140, and the date is not current, can we go on a TN? Is that possible? So it depends. I'd say that one, if you already have an approved I-140, getting a TN can be very challenging because the I-140 says that you want to immigrate to the United States, and the TN says that you have to have ties to your home country. When you filled out your I-140, there is a part of the form that asks, do you intend to adjust status in the US or do you intend to do consular processing? If you selected the consular processing option, which you probably did if you're outside the United States, and you do have very strong ties to your home country, to Canada or Mexico, if we're talking about a TN, you could try to get that visa. The officer would have to be convinced that you do not intend to enter and then try to adjust your status in the United States. Some officers will, understand or align with the nuanced view that intent is assessed at each entry. And if you have the intent when you go for your TN, to not adjust right away and to go back to Canada or to Mexico and do consular processing, you might be able to get that approved, but I would say it's quite risky. It would be quite difficult, and particularly in kind of this environment where I think they are looking at all applications with more scrutiny. So it would be better to try to go if you have an EB-1A. I think an O-1 might be a bit easier, to obtain than a TN because the O-1 has a lower standard for, non-immigrant intent and specifically says just having an approved petition like an I-140 does not by itself mean that you cannot be granted the O. So if you were already approved for an EB-1A, then the O is likely within your reach and would be a better option than the TN. For the EB-2, how many professional letters are needed, like two or three or more? So I'd say most of our petitions for the national interest waivers, include between 4 to 6 letters. But again, it's not so much, as Katie said, it's not so much about what is the number, it's about what is the quality of the evidence. So for example, if you had 4 letters, but they were written by kind of high-ranking government actors speaking to the importance of your work. That's going to be much more compelling than if you have 9 letters, but they're all from, kind of people who are less well known in the industry. So you really want to think about the quality of the evidence that you're providing, the quality of the letter writer, where they, are within the field and things like that. If I qualify for an EB-2, how long will it take for an approval as well as to receive my green card? Again, like if you're qualifying for an EB-2 national interest waiver, usually there's a high volume of evidence that you have to, to kind of put together. I'd say that most of our national interest waiver petitions take at least 3 months to put together, partially because of the need to, kind of create the case profile, bring in all the necessary evidence, get the proper letter writers, kind of get the drafts done. Um, Once the I-140 is submitted, you can pay an additional fee to get a response within 45 business days. And then if the case is current, you can either, concurrently file, or at that time you can file for your green card application. If you're in the US, you can do an I-485. If you're outside the US, it would go to the consulate in the country where you're living for consular processing. So someone's also asked about another membership. Again, as we said previously, like a membership by itself is not going to qualify you or not qualify you. It's going to be looked at in your larger profile. And as Katie said, the things you want to look for are: what were the criteria to join? Did you have to be invited? Can anyone in the industry join? Or what kind of achievements do you have to have in order to be, asked to be a member? Someone's asked, what are the USCIS application fees? So those can be, viewed online. If you Google USCIS fees, you can look them up because it will change kind of depending on the size of your company and things like that. If you're interested in our fees, please do contact us directly, and we're happy to send you our engagement letter, to go over that. Um, Someone's asked, I've been working in the US for over 15 years on a TN with the same company. Will I need documentation from my employer for the EB-2 process? Do I have to mention my employer or no need? You don't have to mention your employer. You can self-petition. That being said, generally the national interest waiver is going to focus on, like your employer will be mentioned, right? Like your work history will be relevant. So no, your employer doesn't have to be involved at all in your national interest waiver petition, but your work history certainly will be relevant. So documentation related to the work that you did there, may be relevant depending on the profile of your case. All right. I think those are all the questions we had. So thank you so much, Katie, for
Thank
sharing
you.
your knowledge. And I hope everyone has a wonderful day.
Thank you. Bye.